to our event, Who Needs EU? The Maastricht Treaty at 30. My name is Silke Ross, and together with Matt Ryan and Valentina Cardo, I'm co-directing the Center for Democratic Futures at the University of Southampton. This is our second event in this year, 2020, and you can find summaries and recordings of past events on our website, which I will put into the chat in a moment. It is my great pleasure to introduce my colleague, Dr. Brian Moss, who organized this fantastic event. Brian is a member of the Department of Sociology, Social Policy and Criminology and of the steering group of the Center for Democratic Futures. Brian's research focuses on policing, probation, and regulation. All his publications involve EU and comparative perspectives. Before his conversion to criminology, Brian studied European social policy in Bath and was fortunate to experience EU matters in action through an internship at the Observatoire Social Européen in Brussels. His interest in EU affairs then progressed to co-authoring a paper about the open method of coordination presented to economic and social councils of EU member states and the European Economic and Social Committee in 2002. This led to an early book chapter on the open method of cooperation with Dr. Rory O'Donnell, then director of the Irish National Economic and Social Council. And I'm now handing over to Brian and look forward to this fantastic panel.
Thank you very much, Silke. Good afternoon, everyone, and welcome to today. What we're going to do very briefly, I'm going to only provide a brief introduction. And what I'm going to do is provide you with an outline of the 5 areas that we're going to cover. The first is citizenship. The second is around justice and home affairs. And the third round is around foreign and security policy, also then social policy, and then finally migration, very much a new and testing issue of the European Union. We don't yet have our speaker in respect of migration, and we're hoping that he will join us in time. But what I'm going to do is, I'm going to start with the social policy end of things, and with Professor Philippe Pochet, to give you a brief introduction, if I may. To say a few words about Philippe. Philippe is the Director General of the European Trade Union Institute and Professor at the Université Catholique de Louvain and Associate Researcher at the Université de Montréal. He was previously Director of the Observatoire Social Européen and held visiting professorships at the College of Europe, at Griffith, Berkeley, Montreal and Harvard universities, and also the University of Madison, Wisconsin and the Max Planck Institute. Philippe's publications on social policy include Social Policy in the European Union, 1999 to 2019, A Long and Winding Road, published by the OSCE and the EQI in 2020. Without further ado, if I can invite Philippe to give us a few words and an overview of social policy in the European Union. Thank you, Philippe.
Okay, and thank you, Brian, and nice to see you again after this long time when you were at the Observatoire in Brussels. Thank you for inviting me. I didn't, before I received the email, I didn't notice it's the 30th anniversary of Maastricht Treaty. And Maastricht Treaty is rather special for me because at that time, Emilio Gabaglio was the General Secretary of the ETUC, the Trade Union Confederation, asked me, could you have a synoptic of the Maastricht Treaty? And I had no idea what is a synoptic. So we worked day and night, all the team, to have a big document. And if you remember, Maastricht compared to the single act is a very big treaty, a lot. And we finished with more than 100 pages comparing the different versions, the innovation, etc. And I have to say that Emilio was waiting for 10 pages and not 120, all the detail. But I think that from there I had a rather good vision of what Maastricht is in all the domain. So what I will try to do for the social side is perhaps to highlight, I think, the 3 points that for me are the most important in Maastricht, speak a little bit what were the development and the problem, and to finish with what is at stake now. So the Maastricht Treaty, I think the first was really the moment of a big conflict, big political conflict, because as you remember, the Major and Thatcher before didn't want to have the social policy at European level, and then it was a fight to try to have something that UK could agree, or to do something without UK, which was not so easy. Now we return to that with the legal approach, but at least the first point, the general point, social policy was really a point of conflict between most of the member states and UK at that time. And the first innovation is to enshrine in the protocol of the treaty, the social protocol, new rules for social dialogue. You know, what is social dialogue? As the audience is very mixed, is the capacity of the European social partners, both sides of industry, trade unions and the employers, to strike a deal. And before Maastricht, they had a provision in the single act, which was very vague, that they can do something with that, but was not really precise. If they wish, they could have a collective agreement. And Maastricht will give a rather complex, but a procedure for the social partners to have deals at European level and transform their agreement into a legal act, into a directive. And that's really important because it is the only international organization when the trade unions and the employers have within the treaty now the capacity to negotiate and to have the result of their negotiation, which is transformed in law and apply for everyone. So it's very clear what I say for one part of Europe. If you are from UK, let's say, okay, what is this system? Because it's completely different of the system in UK. Nor in the past. If you are in Scandinavian countries, it was also rather different in Germany. So what was interesting also, if you look at the period, is there is a lot of literature about Europeanization, but it's really top-down, what the Europeans are doing at national level. And here is really an institution which exists in France, Belgium, Italy, Spain, was uploaded at European level and enshrined in the disposition of a treaty. Was in the protocol is the next point, but was really unique. I think all the process is really unique and was a particular period. And also the discussion, what is a social policy? Is just social policy has to be done by the parliament or could be also done by the social partners. So that was the first innovation in the treaty. The second one was the debate of the competences. Before, most of the disposition were at unanimity, and once again with a huge conflict between the 11 and the UK about what, in a way, what are the remit, what are the frontier of the EU level social policy, and that was decided. It's rather complex, but they decide that some of the policy could be adopted at no longer at unanimity and qualified majority. And that was something rather new, but in the same time, we have something which is rather unique in the treaty, but the other expert perhaps there is in their domain also. There was an explicit exclusion of some of the domain of the social policy. So normally at your level, or you have the policy are only at EU, or most of them, if not all, are shared, but they don't say they're in the treaty. You don't say where there is no competence and you don't want to see a competence. So on wage policy, on strike, on lockout, etc., there is 4 domains that explicitly were outside of the competence of the treaty. In a period which there was subsidiarity arriving as a key debate, but still you had the Article 235, and you can expand for the goal of the integration, the competence. So it was a reduction of the competences. And quickly, I will return to that at the end. So that was also something very innovative. And the third thing was really the monetary integration. From the monetary integration and the end of the possibility within the perspective of EMU to have a devaluation, the social question became really at the center of the monetary and economic integration. It was really interesting, and a lot of my work was about the fight between different group of actors, the economic actor and the social actor, to make sense of the monetary union and the social policy. So briefly, that's the three innovation that's really important in the social side: an innovation about the actors and the instrument, an innovation about the competences and the exclusion of some competences, and the definition of social, not just reduced to the social chapter, but also the economic chapter. So to finish in my 15 minutes, so I have still 4 minutes, where we are now, and that's rather interesting because there is a really different story. In the social dialogue, unfortunately, we are not very far, and on the contrary, there was a kind of resistance and nothing happened for the last 20 years. So we had some development for the first 5-6 years. You have a stagnation, and now there is a clear judgment of the court that the mechanisms that were sought 30 years ago, when the social partners can ask the Commission to propose their agreement to the Council, it's not an obligation for the Commission, but it's an option. So in the country, when the model of the system in Belgium, for example, if the social partners have an agreement, they ask the government to extend that to technically erga omnes, and the government can just say yes or no. And here, and that system was applied at European level. But now the court and the Commission say, because of the monopoly of initiative of the Commission, and very different time 30 years ago, it's not the same actors, it's no longer dollar, trade unions are less strong, etc., and employers much more aggressive. Then the court say the Commission has an option. So what was the logic there is completely destroyed, because if you negotiate and you don't know if your agreement will be a law, you negotiate in a very different way, that if when you negotiate, you know that it could be a directive and you have to respect. So it changed. So this part was not really a success. The second part, which was the legal part, had the up and down that you have already spoken about, the open method of coordination. Brian wrote, I wrote 3 books and I think 60 articles about this soft law. So you had the law, and then you have a period of soft law. Then with Barroso, you have a period of no law in social. And then with the pillar, you return the optimistic, say, okay, that's new period. If you, I'm a little bit old now, I knew what was happening in the end of the 80s. This kind of, okay, it's more or less the same, but much less impressive that we had at that period. So the legal stuff, let's say, up and down, and we don't know what will be the future. Sometimes it had some development, some soft law, so no law, and again some mixed element. But what is interesting is the key challenge now is the framework directive on minimum wage. So what I said that in Maastricht was forbidden to speak about the wage, now we are speaking about minimum wage. Okay, so this framework, the legal service say it's okay. It was really interesting to say in 30 years, the question of wage changed completely on something you cannot speak, something that only the economists and the people from ECFIN were speaking, that the age were too high, to something that wage is about solidarity, and we should have some kind of framework at European level. So the second pillar is rather interesting. And the third one, I think it's really in what we discussed, because then you had in a way, two models. With the EMU, if I go, and I've still 2 minutes, so I think I can do that in 2 minutes. You have really two models. When you have a monetary union and you have a shock, and you have always a shock, symmetric or asymmetric. Some time we had different shock, the COVID, the crisis, etc. If you cannot devaluate, you have solidarity. You have, like in the US, you have a federal state, and you have some kind of solidarity. Or you adapt by migration, you move. Okay, you are in Greece, there is unemployment, you go to Australia or you go to Germany. Most of them went to Australia more than Germany. Or you have kind of social devaluation and you reduce the wage. And then that's one of the model is, or you have more solidarity at European level to stabilize the model. And then you have some a European budget, you have some redistribution, the German would say transfer union, or you destroy the social and the collective bargaining at national level to have some flexibility. And that's really the two projects that we had. Barroso was really to push, to decentralize, to have less social at national level. And now the discussion is, could we have more solidarity at European level? And that's interesting. So if you see the three main points that we had 30 years ago, three different fates, social dialogue disappearing, the legal stuff arriving on the topic that normally the Commission and the member states say we should not speak about that. And here the still big conflict, or always stabilize a monetary union without a political union, and what is the place of solidarity and neoliberal measure at national. So I think with that, I gave you some picture of what is my reading of the 30 years, and I just respect my 15 minutes. Thank you.
Philippe, thank you very much. Moving without too much delay to our second speaker, and hopefully we'll come back to some of the points that Philippe has raised. Turning to Professor Eleanor Spaventa. Eleanor is a professor in law at the University of Bocconi. She has held previous professional and lecturing posts at the universities of Durham, Birmingham, Cambridge in the UK, and visiting professorships and fellowships at the College of Europe and the European University Institute. Professor Spaventa has authored reports for the European Union, for the European Parliament and Commission, and is a member of the Italian Scientific Committee on the Future of the European Union. Her research has been published in such works as Fundamental Rights in EU Law, published by Oxford University Press in 2017. Eleanor, if you wouldn't mind, I invite you to give us your few inputs. Thank you very much.
Hi, thank you very much, and thank you very much for inviting me. As Philippe mentioned, I actually did not click on the 30 years of the Maastricht Treaty, and then that made me think a bit about how much water has gone under the bridge, especially for you lot who are in the UK, and this very sadly, I must say. Now, Brian has asked me to say something about citizenship, which was another one of the big innovations in the Maastricht Treaty. And basically what, the reason why famously citizenship was introduced in the Maastricht Treaties because, as Santor Delors said, you cannot fall in love with the internal market. And it was felt that we needed something that could give a sense of identity to European citizens. And I think, and I'm jumping here already to the end, but I think Brexit, in a way, is the demonstration that this process, the identitarian process, to a certain extent was successful, because one of the the big shocks in the British public for those who had voted to remain in the European Union was exactly about this loss of identity, this loss of European identity. And all of a sudden, European citizenship came alive much more as an emotional and not only legal project. But leaving that aside for a moment, it's clear that from the very beginning, when we introduced the European Union citizenship, no one knew what it really meant. And this is because if you think about it, there is some sort of discordant note. You know, citizenship, which is something that we associate with the nation state, is projected in a supranational dimension. And this is very difficult to conceptualize. And I think we still haven't managed to conceptualize this, really, because it is not at all clear what it means, especially given the fact that national citizenship should be untouched by European citizenship. So a European citizenship is only an additional status, but is not to the detriment of national citizenship. And to a certain extent, the question as to what it means is something that really goes back to thinking about what the European project really is about. And legally, we give different answers at different periods. And we still struggle with understanding whether the introduction of union citizenship in 1992 is really just what was referred to as a cosmetic change. So something that would not change at all the current status of the beneficiaries, so of individuals in the European Union, or whether it was something really innovative. And for me, actually, it is a bit of both. Now, what are the main features of European citizenship? I think a very important part of it, and that one that we discuss less in the legal scholarship, but is much more discussed in the political scholarship, is this idea of giving rights of political participation to European citizens. And those really take the form of two particular rights, which is the possibility to participate to the local elections in the host member state, so the member state of which the citizenship is not a national, both actively and passively, so even being a candidate in city council elections and regional elections, for instance. And this is very important because actually for the first time we have this supranational treaty that actually interferes with the electoral franchise at national level, even though only for the local elections, and the political elections are excluded, and there are very good reasons for that. Similarly, what we see also in terms of participation, and again, this is it goes with the narrative of not penalizing movement between member states, is the possibility for citizens to vote for the European Parliament, both and to actually run for the European Parliament also in the host member state. Again, this is a change because traditionally the franchise for the European Parliament would have exactly mirrored the franchise for the national parliaments. So, you know, you could vote if you were 18, 17 or 21, whatever the voting age, and it would reflect exactly the national one. And all of a sudden we see that from the European dimension, you get a prescription as to who can vote and who can run for it. The active participation has not been probably as successful as the member state, as the European institutions would have wanted, because we struggle to see, there are very few foreign MEPs that are elected in constituencies that are not those of nationality. But there is this attempt to create this almost the first attempt to create a European demos by giving these electoral participation rights. The other very important, and this is what the legal scholarship focuses much more about, and surely the European Court of Justice focuses on, is the right to move and reside within the European Union, which previously was only given provided for economically active people. Then in 1990, it is provided to also economically inactive people, so people who are not participating to the integration project, to the economic integration project directly, although clearly they participate indirectly through consuming goods and paying taxes. But what we have is that we codify this right to move and reside, which is crucial to our project in the European Union Treaty. Now, what happens then is that we move the debate from really the right to reside to the entitlement to welfare provision. Why do we do that? Because actually the member states were not and have not been worried. We are talking here, especially pre-enlargement, but even now, about people moving around. This was not a particular worry. What was the real concern is that actually member states would have to pay for those people, so that all of a sudden, for instance, entitlement to, I don't know, the minimum subsistence, so benefits that are means tested could be accessed also by any European citizen. And then this gave rise to a fear, something that has not happened, but it becomes very, very prominent in political rhetoric, especially in Britain, during the referendum campaign and just before, when Cameron was renegotiating the participation of the UK to the EU, is this idea of benefit tourism. Yeah, so the idea that citizenship to a certain extent is not a cost-free exercise, because you might have a citizen from France coming to the UK just to exploit the wonderful welfare resources of that country. And this then also creates a new sort of reflection or dialogue or fear. But what we see is that actually welfare entitlement becomes a proxy to defining at national and European level who belongs to a certain society. And so, whereas we allow for movement, and we are not particularly worried about tourists, about even people who might want to stay longer, really the fellow European does not belong enough to be entitled to welfare provision, and should not belong enough to be so entitled unless they are economically active. Because if they are economically active, somehow we had, and this now is a bit more question, accepted that economically active people could belong to the host society. From a legal viewpoint, what happens then is that we go in waves of reflection, but also of case law of the Court of Justice, from a very generous interpretation, which is a constitutional interpretation, to now quite a strict interpretation, which is also reactive to certain political dynamics, including the pre-Brexit debate about migration. And finally, and to me this is possibly the most interesting now, development of European citizenship. So if European citizenship changes our sense, succeeds in changing to a certain extent our sense of identity, and ask anyone who is personally affected by Brexit, and they will, testify to that, to the various organizations. It actually, at the end, changes very little in terms of entitlement and what you can do and what you cannot do. But there is an exception to that, and this happens when all of a sudden citizenship is interpreted, European citizenship is interpreted as having to say something about the relationship between the citizen and the state of origin, rather than the state of destination. So all of a sudden, the European Court of Justice interprets union citizenship as being able to determine the relationship that I have with Italy as an Italian citizen. And this is a real, more or less, it's very revolutionary. And it becomes particularly important in relation to deprivation of citizenship. So that now what we have is that whereas before deprivation of national citizenship was regulated only by national constitutional law and international norms that provided that you could not leave someone stateless, now actually you have a new level. And this is a proportionality check imposed by the European Court of Justice that says, basically, the reasoning behind it is that if you take away the national citizenship, you are also taking away the European citizenship. And this is a very serious matter, because once you take away that citizenship, you actually deprive that individual of the possibility of being part of the European project. And for this reason, some constitutional principles of the European Union, proportionality, fundamental rights, and so on, will apply to that decision. And again, this sadly, of course, was quite contested in the United Kingdom, of course, because if you think about when, if you think about really high profile cases, so of the jihadi bride, the Begum case, that might have been decided very differently if the UK had still been part of the EU, because by taking away British nationality, actually what the UK did was would have been also to take away EU nationality, EU citizenship, which sadly was no longer relevant. Now, I think I'm bang on time, which for me is really, really, really rare, and for Italians is unheard of. So I'll stop here, and thank you very much, Brian.
Thank you very much, Eleanor. Our fifth speaker hasn't arrived just yet, and I've been checking with the email to see if there's been some difficulty there. And what I might do, therefore, is invite Saskia to contribute if she could. I'm just going to give a brief introduction to Saskia, to our audience. So Dr. Saskia Maria Hufnagel is a reader in criminal law and co-director of the Criminal Justice Centre at Queen Mary University of London. He's previously worked at the Australian Research Council Centre of Excellence in Policing and Security at Griffith University and at the University of Canberra in Australia. He's held a Labour-Hume Fellowship at the University of Leeds and addressed the House of Lords Committee on Work and on policing issues. Dr. Hufnagel is also the author of Policing Global Regions, published by Routledge in 2021.
Thank you very much, and thank you very much for having me and letting me talk about what's happened since the Maastricht Treaty. Unlike the previous two speakers, I have to say I can't say that it feels that long ago, but that's probably, I remember doing my A-levels when the Maastricht Treaty was done, and that was, yeah, I was already a big fan of the European Union. So I think I felt a bit bad when I saw the title of this talk. It really made me angry, as it does every European or every German who lives in the UK at the moment. I think is a bit shocked of what's happening. However, I think it's a great opportunity to really talk about what is good about the EU. And sadly, I mean, obviously, the theme I'm looking at, which is EU justice and home affairs, is not the theme where we can mostly sort of say hooray at the moment. But I'm trying to make it as positive as I can to talk about this. And in particular to focus on what has happened since Maastricht. And one of the great things that has happened since Maastricht is that we actually call what is now called the area of freedom, security and justice the second most important aim of the European Union. And that's after peace and well-being and before the market. So for some reason, this economic union has managed to put justice, and here in the JHA area, criminal justice and peace and security before the market. So it shows to a certain extent that justice and home affairs symbolizes the EU's political union. And it also kind of symbolizes the EU's shared values. And when we think about cooperation in criminal justice, it's quite clear why shared values and human rights are so important, because obviously we don't want people to move through the European Union as even as offenders or defendants and being treated differently or worse in another country than their own. So it's very important to focus here on JHA also when we talk about human rights. And it's really important to talk about this in times where sovereignty concerns and closed borders become a normality again, I have to say. I mean, with COVID-19, we've seen many borders closing again and the freedom of movement being restricted. We've seen that also in 2015 with migration, that a lot of countries have closed their borders again, and we have new legislation coming up. So it's probably high time to say something positive about JHA here. So what was JHA before, so Justice and Home Affairs before Maastricht? Mainly we had police and justice cooperation, and I'm going to talk less about migration because there are other specialists here. It was a state-to-state sort of intergovernmental engagement. And I have to say it still is to a greater extent intergovernmental engagement, but the EU has managed to channel that to a certain extent into institutions. There were no EU agencies before Maastricht, and then in the 1990s we have the development of Europol. At the end of the 1990s, we have the start of the development of Eurojust. So we have really important agencies that have developed on the back of Maastricht. We also see that legislation in the area of policing and judicial cooperation became possible. And since the Amsterdam Treaty, it then even became legally binding. So even creating more security for people moving across borders. Before that, we had groups of practitioners cooperating. We had informal cooperation. We had both informal police, but we also had informal intelligence cooperation. And we can all see how dangerous that actually might be. Since the Maastricht Treaty, we then had that channeled into agencies that are highly criticized, obviously, but it's better than groups of practitioners such as Trevi in 1975 or the Pompidou Group for Intelligence in 1972 loosely cooperating. The other thing that was incorporated or that pushed Maastricht was obviously the Schengen Agreement and later Schengen Implementation Convention. And that made police cooperation in certain cross-border scenarios legal. Then we have asylum policy, the controls at external borders, immigration policy, and police and justice cooperation in criminal matters, which form the third pillar, matters of common interest. So that is the formation of the JHA through the Maastricht Treaty, which then under the Amsterdam Treaty Title IV was separated into migration and police and judicial cooperation in criminal matters. What was the impact really? And the impact of Maastricht was much bigger sort of under the surface than I suppose over the surface. We can only see the tip of the iceberg. But what happened with the institutions that were involved was that we're looking here at changes that were happening to some of the most conservative institutions in member states. We're looking at changes done to the most sovereignty sensitive areas within the member states. And the interior ministers had massive sovereignty concerns at the time, which they overcame in Maastricht. And police and judicial practitioners were very concerned as well. But Maastricht nevertheless happens. And also they formed these transgovernmental networks that we know now as agencies. What we see today is with Brexit, obviously, and what led to Brexit, the politicization of justice and home affairs. So in particular, through migration, and that obviously had a big impact on Brexit. So JHA being used here to justify leaving the European Union. And also, I already talked about the reintroduction of border controls, which is also one of the downsides of JHA politicization. Just to very quickly, in my last 3 minutes before the 10 minutes are over, talk about some of the agencies. Agencies under Justice and Home Affairs are Frontex, Europol, Eurojust, asylum, drugs agencies, the CEPOL, the European Police College, the Police Chiefs Task Force, fundamental rights agencies, and some others. So we have a lot of agencies that have formed under Justice and Home Affairs, or what previously used to be the third pillar, and that are now, one might say, successful. The success of these agencies has often been, from a human rights perspective, being criticized. But talking about development, I have to say, what was there before Maastricht was much more dangerous than what we have now. Just to also look at other things that have happened, the mutual recognition was probably the most important part of Justice and Home Affairs that Maastricht introduced. And here we have pre-trial instruments like the European arrest warrant, which was also very debated. And here again, I'd like to say that the UK was a very valuable member in the European Union, because they were criticizing everything that happened in this particular area as well. The European arrest warrant was heavily criticized by the UK. They exited it with the Treaty of Lisbon and re-entered it, but they always managed to move the law forward. Yeah, the UK as a critic of the EU always managed, at least in Justice and Home Affairs, to move things into a more human rights abiding direction. And the new 2017 instrument, the European Evidence Warrant, and freezing of assets and bail are other pre-trial instruments here that could be mentioned. And post-trial confiscation orders, financial penalties, probation, transfers of sentenced person. There are so many different instruments that have been developed. And I've just given a lecture actually on the European arrest warrant to a group of international students most of them not from the UK, many of them prosecutors and police officers. And when you say these things to them, they are absolutely flabbergasted. We just look at it and go like, oh yeah, there's a list of things that we can do in the EU, but it's actually groundbreaking that we can do these things in the EU. It is so, as I was trying to say earlier, it is so sovereignty sensitive what is happening here between countries. Police officers, even between some federal states, can't cross into another state, yeah, without losing the power of being a police officer. Here they can basically do that throughout the whole of the European Union with some limits, obviously. So, you know, we have to really see these are massive changes that were brought here. And with Maastricht, they were made into legislation. Yeah, we have legislation on this nowadays. So actually we have more safety than we ever had before. And I think I'm going to just stop here because that's exactly 10 minutes. And I look forward to questions.
Thank you very much for your input. Our final speaker for today, unfortunately, in and of itself, brilliant to have her. Unfortunately, I should say we should have a fifth speaker, but we've lost contact with that for the moment. But our fourth speaker for today is Dr. Shuixuan Chen, an assistant professor in politics and international relations at the New College of the Humanities in London, part of the Northeastern University, USA. She's previously held posts at the SOAS, University of London, the London Pacific Centre of Social Science at King's College London, European Institute for Asian Studies, and at the EU Centre in Singapore. Dr. Chen is writing a book at the moment examining the EU norms and their policy diffusion in relation to the Association of Southeast Asian Nations, and the ASEAN nations. So Chen, if I can invite you to give your few thoughts, please, particularly as it relates to common foreign and security policy and external relations. You're very welcome. Thank you very much.
Thank you so much, Brent. And so can I share my screen because I prepare a short presentation?
Yes, hopefully if it all goes technically, if it all goes well, please do, yeah.
Yes. Okay. Okay, thank you so much again for having me here. And also it's a great pleasure to learn about the European Union's other very important policy areas from other speakers. So today in my presentation, I would like to briefly talk about the European Union's capability and expectation gaps with a particular focus on the EU security strategy towards Asia or the Asia-Pacific region, more specifically. So I think when we look at the history of the EU-Asia relations, actually it dates back to prior to the Maastricht Treaty. But actually it was not until the 1994 that the European Union managed to produce the first comprehensive policy paper towards Asia. And also over the past few years, we can obviously see that the European Union really tries hard to establish itself as a very ambitious security provider at global level. And I think these can be observed from these extracts from the EU's global strategy published in 2016. And then you can have a look at these narrative. And then I think from an Asian perspective, I definitely believe that it's a very, very ambitious idea, because as a nation, it's very difficult to imagine that as a supranational entity, the European Union really wants to project its power, and especially through its external political and security relations with other countries, and also tries very hard to establish itself as a security actor and also security provider at the global level. So in my presentation, I'm not going to talk about the general or the broad EU's global security strategy, but I'm going to zoom in a little bit to focus on the EU-Asia security relations. And then I would like to share the following observations that I have made. First of all, since the early 2000s, and especially after 2012, we can see that the EU has made significant efforts to mitigate the long-standing capability expectation gaps in its relations or in its security relations with Asia. And as a result of many structural factors at the regional and global level, such as during the Trump administration, because of the US adjustment of these geostrategic considerations in the region, and also the rise of newly emerging transboundary security challenges, we can clearly see that the EU has elevated its security profile in Asia, and then also trying very hard to persuade its Asian counterparts that it's a reliable security partner. And this is pretty much in line with the narrative of the EU's global strategy. And then later on, we are going to see that the EU not only proactively increased its resources dedicated to enhancing its security ties with Asia, but also attempt to develop a more coherent and also holistic security policy in relation to the region by expanding and also diversifying its policy instruments with the key Asian partners. And finally, we can observe that when we evaluate the effectiveness of the EU's intention to establish itself as a security provider, it pretty much depends. It not only depends on the recipient, so for instance, the specific Asian countries that we are looking into, but also depend on which specific security policy sectors. And in my analysis, I draw from this analytical framework proposed by Professor Christopher Hugh, and he proposed this idea of capability expectation gaps during the 90s, actually right after the adoption of the Maastricht Treaty. And I do feel that the framework is still very relevant and can provide very helpful analytical tools to understand the EU's relations with Asia. So I'm going to look into, for instance, the EU's capability, and by looking into, for instance, what kind of resources that the EU have been devoted into the region, and also policy instruments and the degree of cohesiveness before looking into both internal and external expectations towards the EU's role as a security actor. So looking into the EU's resources, and then we can note that, and this is not a surprise, that the European Union, when it comes to hard power and military power, this is still lacking, right? And the EU does not really have permanent military presence in Asia. So instead of investing in hard security engagement, I think the European Union mostly devotes its financial resources to tackling a wide range of non-traditional security threats, so ranging from counterterrorism, and I think more recently cybersecurity, maritime security, disaster management, and I think also related to the previous presentation about the Home and Justice Affairs, I think the European Union also tries to promote its own governance modality with regards to border management, especially with ASEAN, for instance. And then one of the most recent example of the EU's financial resources being used to deal with the soft security challenges or non-traditional challenges, security challenges, it's about the EU support to ASEAN's fight against the COVID. And on top of that, I think the European Union is one of the largest development donor in the region, and also it has been a long-standing supporter for ASEAN regional integration and security regionalism. When we look into the EU specific policy instruments, and I'm aware of the time limit, so I cannot really unpack each of these instruments, but if you look into these two tables with regards to the bilateral, interregional and multilateral dialogues and institutional arrangements between the EU and its key Asian partners, including China, South Korea, Japan, and also ASEAN, or more broadly speaking, in the Asia-Pacific region in general, we can observe that, first of all, the EU prioritizes soft security or non-traditional security issues than the hard security challenges. And secondly, despite the fact that the European Union, it's a relatively new security actor in the region, but we can still see that it managed to establish a very wide range of institutional networks and also dialogue networks with its key Asian partners, which I think is actually a big success, I would say. When we look into, for instance, the EU's degree of cohesiveness, and we can definitely observe that over the past few decades, and especially after the Lisbon Treaty, the EU introduced a number of very interesting innovations, including the establishment of the HRVP and also these very unique external action services, for instance. So all these institutions actually helped the EU to develop a relatively coherent image as an independent actor in Asia. But in practice, we can see that confusion and divergence with regards to the EU security policy towards Asia can still be observed. And empirical evidence still suggests that member states within the EU sometimes struggle to reach a unified position on Asia. And one example is the member states' very different positions on whether the European Union should participate in China's Belt and Road Initiative, for instance. And then additional factors that might constrain the cohesiveness of the EU security policy in Asia is the divergence among individual or the different EU institutions. So one example is that when the EU approached ASEAN as another regional organization, the European Commission and the Parliament might have different priorities. For instance, they need to balance commercial economic interests and those fundamental values such as human rights. So, and finally, I think it's very interesting also to look at the expectations. So if we look into the internal expectation, which essentially it's about, for instance, the EU institutions and its member states' expectation towards the European Union's role. And then again, the past decades has really witnessed a considerable increase of the EU's internal expectation concerning its security role in Asia. And I think this trend has been reinforced in recent years, especially in light of this ongoing volatility in the region. And again, against the backdrop of COVID-19 pandemic as well. And when we have a look at the external expectation, and I think there exists a very high level of imbalance between internal expectation from the EU and external expectation from Asian actors with regards to the EU's role. Because, for instance, in comparison to US or for some countries, China, most Asian countries still do not consider the European Union as a consistent, coherent, and also strategic security provider in the region. So maybe the European Union has become recognized as a security contributor, but perhaps not as a security provider yet. However, I think the positive thing is that an increasing level of transnational security threat or non-traditional security challenges in both regions, in both Asia and Europe, has actually created new window opportunities for the EU to participate in Asia's security governance. And I think the European Union has long been a very active contributor and participant in the ASEAN regional forum to share its own experience, for instance, with regards to cybersecurity governance and maritime security. So I think in the longer term, we do hope to see that these capability and expectation gap can be further mitigated in the EU's relations with Asia in its security policy. Thank you so much. And I also look forward to any questions.
Thank you very much for that. If I may, and just if there's any questions going to come in from any people watching, or indeed from the panelists to other panelists, if I could just pick up on one point that Chen has raised there, which is about expectations, just across the various fields that we've heard from today. What do we see on the ground from the public as being expectations? Do we have any sense of expectations in the Justice and Home Affairs, in the social policy field, or within external relations? Does the public, is there any sense that the public has particular expectations of the EU?
If you wish, I can start.
Please, Philippe, if you could, yeah, that'd be great.
Well, I think the expectation it's not based in scientific analysis, but more, I think the social stuff has evolved the last 30 years. In the Maastricht time, people were optimistic. You know, really, that's kind of they had the impression that